So I think are you ready on Mr. Schuster's case, Ms. McDonald?
Well, Mr. Schuster, just to give Your Honor a little bit of background on this one, Mr. Schuster is representing himself. The court has previously gone through the waiver of right to counsel. When we were here, I believe the last hearing, Mr. Schuster gave an indication that he wanted to resolve these matters. So I have drafted a plea form with the city's offer on it. I just am not sure how to get it to him. I can certainly send it to him in the chat. I just don't know if he has the ability to download that and sign it if in that respect. So,
hi, ma'am. How are you today?
Hold on a second. So let's the preliminary matter. This is Jonathan Schuster, 4A0525-748. So it sounds like Ms. McDonald's trying to get you some documents, Mr. Schuster.
Yeah, so for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary. I had mailed out some paperwork over to the prosecution as well as submitted it to the court. Have you received those, ma'am?
So I've received two motions from Mr. Schuster. Have you?
Yeah, the two motions as well as the affidavit, as well as the certified copy of the so you got that paperwork. Were you able to read it?
I have two motions. One was both were received today.
Right. You should have received an affidavit as well.
I don't see any affidavits.
It's on the back.
The affidavit was received at the same time that the motions were submitted. And
I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I emailed to Ms. McDonald this morning.
You did, I'm sorry, what, Madam Clerk?
I emailed to you a copy of the first motion to dismiss and the affidavit approved, it's called.
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster. Hold on, Mr. Schuster.
So those were sent over.
Hold on, Mr. Schuster.
As well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
I just wanted to make sure I said that. Thank you.
Madam Clerk, did you send that to my email or did you send it to the office email? Because I don't have anything from you today. Except the orders from Mr. Bailey Garrison. And the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine. I just require that due process is, that we.
Okay, hold on, Mr. Schuster. There's going to be plenty of time for you to talk.
Yes. Thank you. Also, the prosecution, I've never received anything from you as well, but there is an email on for contact information, so you can send that over via email if you have anything to send to me.
We sent you discovery at both addresses that you gave to the court, so they were physical copies because there's digital evidence as well.
Well, I just have never received anything from you.
Well, it went out to your mail, so I don't know what to tell you about that.
Did you check, Mr. Schuster?
I mean, I haven't received anything.
That's not my question. My question is, are you checking your mail regularly?
Oh, I definitely look out for mail regularly.
Okay, and does the court have your current address?
So he updated it, Your Honor. We actually had this situation issue a couple of weeks ago, or actually almost a month ago, where we had sent out full discovery to the defendant, and then he indicated that that wasn't his address. So we sent out another packet of full discovery to him to the address that he updated. Let's see, the one on Kenyon Street.
2318 California Avenue.
You gave us on January 27, 600 Southwest Kenyon Street, apartment G201 in Seattle.
You're talking about on January 27th when the judge denied subject matter jurisdiction that day?
So the address that you gave to the court on January 27th was the 600 Southwest Kenyon Street, apartment G201. So
the same day that
that was
Mr. Schuster
denied subject matter jurisdiction.
Mr. Schuster, Is that the
Mhm.
address you gave on January 27th?
I don't recall, but I do have, somewhere she can send it to so
Well,
that
we're not gonna play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it and I don't recall. Um, I, so
You
I'm giving you an address, but
You
um,
recognize that address?
which address?
Can you read that one more time, Ms. McDonald?
Yes, the address on January 27th that he requested discovery go out to was 600 Southwest Kenyon Street, apartment G201 in Seattle. The one prior to that he requested was 1005 North Cleveland Street, apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the
Um,
judge denied your motion to dismiss for lack of subject matter jurisdiction. The court found that there
no,
is
she
subject
did.
matter.
It was on the record. She denied subject matter jurisdiction. She didn't deny my motion. That wasn't until later. But regardless, you did receive the two motions as well as the affidavit today. Is that correct, ma'am?
I did. Did Ms. McDonald, have you gotten that yet?
I just
Perfect. Have
So,
you
so
have
Mr.
you had a chance
Schuster,
to read over that, Miss
so
or ma'am?
obviously Ms. McDonald has not had a chance to read over it.
Oh, I was referring to
Provided
you,
to her.
ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th? Where you said you wanted to go forward representing yourself?
Well, from the very beginning of this
Remember
matter,
signing this piece of paper saying you were representing yourself?
from the beginning.
That's not my question, Mr. Schuster.
I'm answering your question. I would like
I
to
don't want a
speak.
narrative. Yes or no?
Thank
Do you
you.
remember
Uh,
signing this piece of paper?
I don't recall.
Okay,
I
well,
don't know
your
what paper you're
signature is
showing me.
here on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just very
Schuster,
hard to read because it's
okay,
blurry from this
so
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules.
Well, this isn't a trial, so
Nonetheless, I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I've reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion, finding that this court, again, does have subject matter jurisdiction, and this case will proceed. So those motions are denied. I am also not really interested in hearing that you have yet a third new address for Ms. McDonald to send discovery to. So at this point,
It was never a third. In the beginning, you had the correct address. It's no longer the correct address.
then it's
And
not the
so-
correct address. If it's no longer correct, then it's not correct. You've given a.
Well,
Kennewick
as
address.
of recent, as of literally not that long ago.
So when
So-
did the Kenyon Street address become a bad address?
I want to say within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
I mean, it's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, it is not, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated.
I can
And
tell
this
the
is a
court,
court of record, correct?
Is a court of record.
You said this is a court of record?
It certainly is a court of record.
Ah, I see.
We are on the record now. So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that everybody has the correct information.
What is your current correct address?
The mailing address would be 2318 California Avenue. I believe that's Southwest. D.
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
Family. And so, just so I'm clear, you're saying that the right to travel and privacy is not a federal matter, and that
I'm
you're
saying
saying
that-
that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington. And that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty and, a right, because no person shall be deprived of life, liberty, or property. You're saying that isn't a federal matter?
This exchange perfectly captures the core misunderstanding behind the sovereign citizen right to travel argument. The defendant keeps treating the existence of constitutional rights as proof that governments can't regulate conduct connected to those rights. But constitutional rights are not unlimited immunity shields. Freedom of speech exists, yet there are still laws against threats, fraud, and defamation. The right to travel exists, yet states can still require licenses, insurance, and compliance with roadway safety laws. The judge is actually being incredibly patient here because she keeps narrowing the issue back to reality. This is a municipal driving case, not some grand constitutional showdown, but he keeps trying to elevate it into a federal liberty battle because sovereign citizen ideology depends on reframing ordinary criminal charges as government oppression. That's why you constantly hear phrases like life, liberty, and property repeated dramatically in these hearings. It sounds profound until you realize none of it changes the underlying traffic statutes he's accused of violating. And here's what viewers should pay attention to. Every time the judge answers directly, he immediately reframes the question instead of engaging with the answer. That's not legal advocacy. That's somebody trying to force the conversation back into a script they memorized online. Do you think he actually believes these arguments are winning, or is this more about refusing to admit the court has authority over him at all?
I'm saying that there are multiple layers of jurisdiction that involve travel, and that the fact that there are federal rights around travel does not preclude Lake Forest Park Municipal Court from enforcing state and local ordinances. So what do you want to do on your case today, Mr. Schuster? Is it your intention to go to trial next week? Is it your intention to entertain a plea offer from Ms. McDonald?
Well, I just want the court to know that any judgment issued without proper subject matter jurisdiction is void and may be challenged at any time.
And you're free to
This
appeal
court
any ruling from
lacks
this
the
court.
authority to hear this case, and proceeding further would result in an unenforceable judgment. Therefore, this
You are
must be
free-
dismissed.
You are free to appeal any ruling this court makes. You can certainly, since you
Almost definitely.
how to do that. Nonetheless, we have to figure out what you're doing today on your case. It's your readiness hearing, where you tell us if you want to go to trial next week or if you want to entertain a plea offer from Ms. McDonald. And I'm
Well,
happy-
as I've stated, this case should be moved to the proper courtroom, which it's not.
In the
And
proper
so
courtroom, and that's
if
not
it's
happening, and Mr.
not,
Schuster,
if it's
motion
not
has been
transferred,
denied.
I do,
hearing
it
further-
should be dismissed.
I'm
And
not
if it's,
entertaining further motions to dismiss. Ms. McDonald, go ahead.
Yes, and Mr. Schuster, I sent to you in the chat because that is the only way for me to get that to you right now.
oh no, you have my email. You
The
got the information on the motions there. So
So-
you have the email listed above. I don't
Mr.
really know how to use Zoom like that, and
Well,
so sending anything over through
it was
chat
the
like
same-
this is just it's difficult. So email would be the best way if you want to get that to me faster. But
I'm
of
using-
course, you have an address now that I'd be able to get the mail that you're saying you've sent already. But no worries. So.
I'm using Zoom the same way we used it at the last hearing when we sent you documents and you were able to chat back and forth with me. So it's in that
We
chat.
didn't have a back and forth
We did.
chat. No, we didn't.
So there is a document in the chat for you to open and take a look at, and that is the city's plea offer. We are agreeing to dismiss 2 charges for a plea to 1 with a credit for time served recommendation. So
Well,
if you'd like
as
to
I
take a look at
stated,
that,
you can email it so that I can properly see it, because that's the best way for me to do it quickly. Because I don't really know how to use this chat function in Zoom.
Ms.
So-
McDonald, do you have the ability to email it to him?
I'm looking for the email.
Yep, it's at the top for the motion to show cause, as well as the bottom of the motion for dismissal. But I can also just read it to you if you'd like that.
If you can put that into the chat so I can make sure that I don't spell it wrong, that would be great.
Well, as I've told you, I don't know how to use the chat.
All right, so we're streaming live to YouTube, Mr. Schuster. Would you like to read your email for anyone who's watching YouTube to listen to and hear?
I mean, they can email me. I don't mind.
Then
Yeah.
Spell out your email for Ms. McDonald.
Do you know how to spell my last name, Miss McDonald?
Please just spell it out. Let's just be as clear as possible.
Well, it'd be my last name dot jon@icloud.com.
Can you spell your last name for her?
Yeah. Are you ready, Miss McDonald?
Yes, I am.
Okay. SCH.
Okay.
Can you hear me?
Yes, I can.
Oh, okay. I wasn't sure if you could hear me. I know we've had trouble communicating over Zoom because sometimes you can't hear. But SCH, USTER,
Okay.
you got that?
Yes.
Oh, okay. So
Is
my
it?
last name,
Uh-huh.
John, JON,
Okay.
you got that?
Yes.
Oh, okay. At iCloud.com. And, it's actually pretty ironic that you say that about the email, but then mailing addresses are said out loud too. So that's just kind of ironic
So far,
that you would mention that.
yeah, well,
But
as I said at the beginning,
nonetheless, it's okay.
of court, everything's being broadcast on YouTube, but
Oh, I know.
we
But
need to
nonetheless,
respond to the fact that you have changed your address repeatedly. So Ms.
nonetheless,
McDonald
that's
is
just
emailing you,
ironic.
Ms. McDonald is emailing you a copy of a plea offer. that
Cool. You said you were going to send that in the mail as well. So, or
No,
information in the mail?
that's not coming in the mail. It's coming via email right now. You have the
Oh,
opportunity to
I'm
review
talking
it right
about
now.
like the other information she was.
No, that's
sent
already
over.
been sent in the mail. You need to go to wherever those addresses were to get your discovery.
Mm.
The discovery was sent out on February 10th, approximately a week and a half after you gave that address on the record.
On the record, when the judge denied subject matter jurisdiction
When you were in court on the record.
on that day, when she said she denied subject matter jurisdiction. Yes, I remember her denying subject matter jurisdiction.
You also gave an address. Ms. McDonald sent your discovery to that address about a week later.
So you're saying that you can't send that to the proper address, Ms. McDonald?
We've already sent it to both addresses that you have provided to the court.
What she's saying is you can't come to court once a month, change the address, have her send out discovery, and then come back a month later and say that wasn't the right address to send it to.
So you're not going to send it to.
You can practically feel the judge and prosecutor losing patience at this point. The discovery issue has now become a full-blown comedy routine. He claims he doesn't understand Zoom chat, doesn't know how to retrieve documents electronically, and can't properly access the plea offer. Yet somehow he's filing motions packed with constitutional language and jurisdiction claims. The selective confusion here is incredibly convenient. What makes this even more bizarre is how many opportunities the court is giving him. Most defendants would love this level of patience from a judge. The prosecutor is emailing documents directly, the court is explaining procedures repeatedly, and they're still trying to accommodate him despite all the interruptions and circular arguments. But instead of using that opportunity productively, he keeps redirecting everything back to jurisdiction and mailing complaints. And then comes the accidental cell phone of the hearing. He openly acknowledges the hearing is being streamed live while simultaneously reading personal information aloud anyway. That little irony, the judge points out, completely deserved. This entire situation feels like someone trying to outmaneuver a legal system they fundamentally don't understand. And unfortunately, that usually ends badly for the defendant, not the court. At this stage, would any of you still be considering a plea deal? Or do you think he's already fully committed to taking this to trial no matter what happens?
The proper address. Okay.
Did that get sent, Ms. McDonald?
Yes, it did.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right?
And
So
so my
Go on.
email,
You
I'm
can
using
go
the
off
same.
camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Ah, okay, okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get back on it.
Okay, okay. One moment.
Can you mute yourself, Mr. Schuster, and turn your camera off to read your email?
Oh, I saw that Carmen had sent something over.
Yes, you need to open it and review it.
Oh, I mean, it says what you had said on the record, correct?
No, it's an entire form. It's about, see how many pages that is? About 8 pages.
Can you mute yourself and take yourself off video while you review that, Mr. Schuster?
I think so. Let me see if I can do this correctly. Oh, so yeah, I see everything that you've sent over. Um, Obviously, I'd probably have to look at it longer to make sure
I'm
I read
asking
it
you to do that.
carefully.
I'm asking you to do that now. We're gonna go back on the record.
Oh, okay. It just might take some time. I mean, I've gotten through some of it, but for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time for all of that, but if you do, I don't mind, taking the time to fully get into it.
Ms. McDonald, you're on mute.
If he's asking for more time to go over the city's offer and to consider that, I don't have an objection to continuing the matter if he agrees to waive speedy trial.
Oh no.
Well, if you don't wish to waive speedy trial, then
Well, if she doesn't want to give me more time, then I guess we just got to
Well,
you
the
know.
problem is, Mr. Schuster, you have to be brought to trial within 90 days of your arraignment date. And so your trial is scheduled for next week, but if you want to take advantage of the city's
On the
offer,
11th,
right, if you want to take advantage of the
9
city,
a.m.
if you want to take advantage of the city's offer and you want more time to review it, unfortunately, you would need to set over that trial date.
Well, I can counter to you right now if you'd like.
I'm happy to go in a breakout room.
I don't know what that means.
I don't know that these are necessarily conversations to have on the record, but
if you want to go into a breakout room, in other words, go into a separate Zoom room with just Ms. McDonald so you can discuss her offer, I'm happy to allow you to do that right now.
Okay, how does that work? How do we do that on Zoom?
I can do that. I can put you in a breakout room. You'll get an invitation.
Do I
Something
need it? Okay.
pop up on your screen for you to accept.
Okay, so just wait until something pops up.
Yep, I'm going to put you in there right now. It will be into room 1.
How would I come back though?
There will be a button on the bottom right that says leave breakout room and back to main session.
Okay, so it says join breakout room.
Yeah.
Prosecutor McDonald is inviting you to join room 1. So I
Yes.
just click join.
Yes, and I'll be in
Okay.
there.
All right.
So we're back on the record with Jonathan Schuster for A0525748. Mr. Schuster had an opportunity to speak with Ms. McDonald in the breakout room. And Ms. McDonald, where are we?
Yes, Your Honor, I'm a little bit concerned because it didn't appear that Mr. Schuster was, and I was kind of having a hard time discerning whether or not it was a willingness or an ability to track the conversation.
Oh, objection. I
So-
definitely have the ability to have a conversation and track what's going on. I offered her a counter and she didn't want to take it. And so that's where we are, ma'am.
So I do have some concerns there. Also, Your Honor, I did just pull up his criminal history. It appears that he does have an active warrant out for his arrest for a DUI.
Active warrant.
SMC bench warrant from 2/14/25.
Yes, that is the one. So I have a couple of concerns. The concern is the defendant is saying he doesn't have discovery. He has not read the reports. I asked him several times if he was prepared to proceed to trial on all 3 charges next
And I
week.
told her 9 o'clock on the 11th, I will be there.
So
mean,
Yeah.
Mr. Schuster, that you're intending to go to trial without?
Right. And you're saying there's an open warrant? Is that King County? Is that who that's with?
So, Mr. Schuster, the Seattle Municipal Court issued a bench warrant for $5,000 on February 14th, 2025.
Okay. And so I'll need to obviously reach out to them so that we can get that quashed and taken care of,
That is true. You will need to do that.
which I will do as soon as we're done here.
My expectation, if we're having another hearing next week, is that you will have done that before the next hearing.
Oh, 100%. No need to be walking around with warrants. That is unacceptable.
Did you catch how dramatically his demeanor changed the second that warrant came up? Suddenly, the endless constitutional speeches slowed down, the interruptions decreased, and he became laser-focused on solving the warrant issue immediately. That's one of the most revealing moments in the entire hearing because it shows he absolutely understands when legal consequences become personally dangerous. And now the prosecutor is openly raising concerns about competency and his ability to track conversations. That is a massive development. Courts do not casually bring up competency evaluations. The prosecutor is essentially saying, I can't tell whether this person is intentionally obstructive or genuinely unable to comprehend the proceedings. That's serious, especially after the bizarre back and forth in the breakout room we didn't even get to hear. What's fascinating here is that sovereign citizen defendants often blur the line between ideology and actual confusion. Some are manipulative. Some are deeply misinformed. Some genuinely convince themselves they've uncovered hidden legal truths. But when the prosecutor starts questioning whether you can meaningfully participate in your own defense, the entire tone of the case changes. And let's not ignore the irony. Moments earlier, he was acting helpless about Zoom functions, yet during the recess, he apparently navigated municipal warrant procedures online with zero difficulty. Amazing how quickly technological literacy returns when arrest becomes a possibility.
So, Ms. McDonald, are you raising 1077?
Well, I would ask that the court engage in a colloquy because like I said, I was having a difficult time assessing that because I don't know if it's an inability to track it
Objection.
appropriately or if it's
Nothing to
unwillingness.
So Ms. McDonald is asking that I ask you some questions to make sure you're able to proceed.
Objection, Your Honor.
Mr. Schuster, there's
I've
nothing
told-
to object
It's been
to.
on the record. I'm ready for whatever we need to do on the 11th outside of quashing this warrant that I just recently found out, as you've said it. I didn't even know that was a thing. So now I have to just take care of that. The 11th, I will be there at 9 a.m.
So Mr.
I'll-
Schuster, I'm going to ask you some questions. First and foremost, do you know what happens at a trial?
Do I know what happens at a trial? Yes.
Can you describe that to me?
What happens at a trial where we meet and go over the facts and determine whether or not that I will be charged with the allegations against me?
So who decides whether you're guilty of the allegations against you?
Well, of course, it's a trial jury.
So who's on a jury?
Well, my people. I mean, it's the people of, it's the people. Obviously, it's a jury trial.
Do you know the difference between a bench trial and a jury trial?
Yes.
What's the difference?
One, there's people who make the decision, and one, the bench makes the decision.
And who's the bench?
Well, I believe I'm speaking with her currently.
So the judge is the bench.
The magistrate.
What are you charged with right now?
You want me to like say it off my memory or read the actual
Tell me.
charges from the? Because I have my paper. I can go get it real quick so I can
I
read
don't
it.
need you to read it to me. I need you to tell me to the best of your ability what you're
Oh,
charged.
okay, yeah. You're charging me with, or the allegations are driving with a license suspended, third degree, no interlock device, failure to comply. Is that correct?
Correct.
Yes.
You know what the maximum penalty for each of those charges is?
Not off the top of my head. No way. I'd have to look at my notes.
Do you understand that DWS third degree is a misdemeanor punishable by 90 days in jail and $1,000 fine.
I understand the allegations against me, correct?
And that there's also a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine.
I do understand the allegations against me.
What would the city have to prove if you went to trial?
That the allegations are true. They'd have to have an injured party show that the allegations are true. And of course, they'd be able to present their beliefs over to the jury, and the jury decides. I'm not sure what we're doing here. I mean,
Asking you questions about the trial process to make sure that you understand the trial process.
well, I have the right to present myself in court, and that's what I'd like to do.
Ms. McDonald, I'm not getting enough to raise 1077 at this point. I do understand your concerns.
Right.
I have concerns over Prosecutor McDonald and her ability to understand what's going on, but that's okay. I'm not going to raise any challenges or anything against that.
You
I
don't,
just want that noted.
This competency colloquy is honestly painful to watch because the judge is giving him every possible chance to demonstrate basic understanding of the trial process. And he's barely hanging on. These are extremely foundational questions. What is a jury? What's the difference between a bench trial and a jury trial? What are your charges? What penalties are you facing? These are things any defendant representing themselves absolutely must understand. And then we hit the classic sovereign citizen talking point again, the injured party argument. This misconception shows up constantly in these cases. They believe every criminal charge requires a directly injured individual standing in court accusing them personally. But criminal law doesn't work that way. Many offenses are considered crimes against the public order or against the state itself. DUI laws, licensing laws, reckless driving statutes. These exist because governments have authority to regulate public safety, not because every case needs a specific victim sitting in the courtroom. The judge is trying so hard to explain this patiently without escalating the situation, but he keeps looping back to the same misunderstanding. At some point, self-representation stops being empowerment and starts becoming self-destruction. And this is exactly why courts strongly encourage defendants to use counsel. Confidence without comprehension is a dangerous combination in a courtroom.
But regardless, I did give her a counteroffer, which was very reasonable. She declined, and so the next step would be, for this court would be the 11th at 9 a.m. Is that correct? Is that the right time?
that's correct. Ms. McDonald, do you have the ability to send over the electronic discovery to the courthouse for Mr. Schuster to pick up?
So we would have to, so the electronic discovery, we have the body worn camera and all of that information that had to be burned onto CDs and sent to him because it's too large to send
You said
via
CDs.
email. So that was all sent out to his address. We would have to
You
redo
said it
all
was
of,
CDs. You said.
yes.
Some of the body worn cameras on CDs because it's too large to send any other way, Mr. Schuster.
You still use CDs. Is that what that is wild.
Well, you are held to the same standard as attorneys, and attorneys are expected to.
I'm just surprised that you still use CDs.
Is there anyone that your office could, ABC Legal or something like that, that your office could get that over here quicker than the US mail?
Well, we would certainly be able to bring it to our office. Isn't that far from the courthouse, so it's not a difficulty in the transportation. It's just it would take my office probably the better part of the afternoon or tomorrow morning to get all of those burned to another set of CDs because there's several.
So if I ordered that, your office bring a set of discovery here, for Mr. Schuster to pick up after 10 a.m. on Friday. Would that be doable?
I would think so.
Okay, so Mr. Schuster, I'm going to have Ms. McDonald's office make you another copy of the discovery, burn the electronic medium onto CDs, and it's going to be available for you here at the court window after 10 a.m. on Friday. That is going to be the only additional discovery that you get. You need to find a way without driving to get here or get someone here to pick that up for you. That will be the only additional copy of the discovery for you. Will be here at the courthouse for you to retrieve. The courthouse is closed on Saturdays and Sundays. So if you want to prepare for your trial, I recommend that you come Friday after 10 a.m. to do so.
And I'm wondering if we can just pass this for a moment so that Mr. Schuster, I would ask that he read the plea form through in its entirety, because I think that that does impart some of the things that he needs to take into consideration, which I don't think that he's necessarily considered, while we take the plea on the Partida Garcia matter.
I'm ready to proceed to trial on the 11th. Outside of quashing the warrant with, you said it was Seattle Municipal or King County?
Seattle Municipal Court.
Seattle Municipal. Outside of quashing that warrant, I am ready. I do have one question though. This is a criminal matter, so who was the injured party exactly?
The city of Lake Forest Park has
The
filed
city
charges.
of Lake Forest Park. Okay, and they'll be present at the trial. I'll be able to face them.
They are represented by Ms. McDonald's office.
So the city is the plaintiff as well as the judge. Is that what you're
The
saying?
city is not the judge. The
Lake
city,
Forest Park is not the magistrate for this matter?
Lake Forest Park is the municipality in which this court takes place. Judge Grant will likely be here next week. She is the judge. She does not represent the city. The city is represented by Ms. McDonald's office.
So the judge doesn't work for the city at all, is what you're saying?
She is a neutral arbiter of matters. She is not representing the city.
So she doesn't work for the city?
No, she works for the courts and the court system.
Ah, okay. And
Ms.
during
McDonald,
trial, the prosecution will be able to bring the injured party forward, correct?
during trial, the prosecutor will be afforded the opportunity to bring forth its witnesses. I suspect that will be
No,
more.
I'm saying the injured party.
I'm talking, Mr. Schuster. Okay.
Oh, I hear you. I hear you. I just wanted to make sure it
The
was clear what I
prosecutor has
said.
the ability to bring forward its witnesses. They have the right to cross-examine any witnesses that you bring forward. You are allowed to bring forward witnesses at no expense to you. You do have to comply with the court rules in terms of giving Ms. McDonald notice of any witnesses that you intend to call. So you can't show up on the day of trial having not notified her of potential witnesses and suddenly
Okay.
this is on her.
Okay, I guess I wasn't clear when I asked you because I wasn't asking about witnesses. I was asking about the injured party.
There doesn't
She's
have
been,
to be a named injured party. The
well,
allegation,
I have the right to face
you have the right
to face the injured party who's
cross-examine.
making these allegations against me.
You have
And
the right to present a
she'll
case
be
on
able
your, Mr.
to,
Schuster, stop. You have the right to present
Okay.
a case on your own behalf. You have the right to hear and call witnesses at no expense to you. You have the right to question the city's witnesses. Okay, you have the right to cross-examine their witnesses. But
I also have the
there
right
does
to
not
face
have to
somebody
be a
who's
per se
alleging.
injured party, which is what you're getting
Well,
at.
I mean, in a criminal matter, there definitely needs to be an injured party.
This is one of the clearest examples of how sovereign citizen arguments completely collapse under even basic legal scrutiny. The defendant keeps demanding an injured party, assuming criminal prosecution only works if an individual personally suffered damages. But criminal law isn't civil court. The state itself can prosecute conduct that violates statutes designed to protect public safety and public order. That's why governments can prosecute offenses like driving with a suspended license, DUI, reckless driving, or firearm violations, even if no immediate accident or injury occurred. And notice how the judge carefully avoids getting dragged into philosophical debates. She keeps returning to procedure, statutory authority, and courtroom logistics because that's what actually matters legally. Meanwhile, he continues trying to turn a misdemeanor traffic prosecution into some constitutional revolution about liberty and travel rights. But the funniest part may honestly be his shock over discovery being burned onto CDs. The guy who claims modern courts lack jurisdiction somehow can't believe government offices still use physical media for large evidence files. That exchange alone sounds like satire. Yet despite all the confusion, delays, and bizarre arguments, the court is still bending over backwards to ensure he receives discovery and gets a fair trial. That's the irony of these hearings. The very system sovereign citizens claim is unfair often gives them far more patience and accommodation than most defendants ever receive.
You ready to go back on the record on Mr. Schuster's case?
I think so.
Your Honor.
So this again is Jonathan Schuster, 4A0525748.
Yes, I am here.
So when we last left off, we were, I believe, setting this for trial next week.
Yeah. I did want to clarify some things from earlier, if that's okay with you, ma'am.
Okay,
Because you had denied both of the motions, and I just want to make sure I understand correctly why they were denied. So would you be able to repeat that, please?
so again, as I stated before, your motion to dismiss is based on an allegation that this court does not have jurisdiction over driving offenses based on the right to travel articulated under the federal and state constitutions. The federal and state constitutions do not limit the states and municipalities' rights to impose traffic laws or driving requirements such as driving licenses and things like that. So there's no federal preemption of these laws. They are appropriately codified and appropriately enforced in the city of Lake Forest Park. So there is subject matter jurisdiction that this court has based on the fact that these offenses are alleged to have occurred in the city of Lake Forest Park. There's subject matter jurisdiction because this court is authorized by statute to function and to enforce these laws. And so for those reasons, your motion to dismiss is denied.
Okay. And so essentially, it's because they don't limit the state municipalities' ability to impose driving statutes. Is that correct?
Yes, you've cited the right to travel broadly articulated in the federal constitution. But nothing about that is contradictory to Washington's right to impose driving licensing requirements. And nothing about that federal constitutional law prohibits the city of Lake Forest Park from enforcing traffic regulations.
Okay. So it was denied because they do not limit the state's municipalities' ability to impose driving regulations.
So this court does have subject matter jurisdiction. We will be going forward unless you want to enter a guilty plea today with a trial next week. Is this going to be a bench or a jury trial?
Oh, a jury trial, for sure.
So we will set this for a jury trial next week. Again, Mr. Schuster, discovery will be available to you at the counter at the courthouse after 10 a.m. on Friday. It is the court's expectation that if you want to review that prior to trial, that you come down here and pick it up. There's not going to be a third mailing of discovery to a new address. The court's not going to entertain next week any kind of arguments for continuances based on you not coming down here or having someone come down here and pick that up. Ms.
Okay.
McKee's not going to keep mailing things to different places.
With the court
Okay.
setting an intervening pretrial for Monday as well.
We can certainly do that. We can set a pretrial hearing for Monday.
I won't be able to attend on Monday. Tuesday would be the soonest I'd be able to make it to court.
I would ask for Monday, and I would ask that it be in person, Your Honor,
Um,
so that we can make sure that he's had the opportunity to review the discovery, and we can have those assurances prior to calling in a jury.
I am gonna require you to be in court on Monday morning, Mr. Schuster, 9 AM in person.
I don't have the ability to make it on Monday, ma'am.
Why is
Uh,
that?
Well, first, I do have other obligations with work. Outside of that, I had set up transportation to make it up there because, as you both know, I don't drive. And so I had set up transportation for Tuesday specifically to make sure I'd be able to attend that. And so I have no problem attending on Tuesday. I just don't have the ability to physically get there on Monday. Outside, I mean, plus I have to work. Obviously, work isn't the main thing, but um, I just physically don't have the ability to make it there on Monday.
Well, then we'll set this for Tuesday. Is the court's expectation that you're gonna come pick up the discovery? We're not gonna entertain continuance motions based on not picking up the discovery.
Of course, of course.
Well, Your Honor, and the other reason that I'm asking that we set it for Monday and that he be required to come is we also have the Goodwin matter that we are still anticipating will be set for trial that week as well. And by then, we're going to have a lot more information. And I do want to ensure before we walk through the door on Tuesday morning to start trial that Mr. Schuster is prepared.
Ma'am, I am
all of-
100. I am ready outside of the warrant that was brought to my attention today. But during the recess, I actually had a chance to fill out the forms on the Seattle Municipal Court site. So,
I'm more concerned about the discovery and the body worn
So,
camera footage and
since prior to the recess, am 100% ready for um, Tuesday at 9 a.m.
My concern, Ms. McDonald, is, to his point, if he doesn't have transportation, I'm not gonna ask him to drive here.
then at the very least, do one via Zoom. I'd prefer it to be in person, but I do think that we need to have that.
If you need me here on Zoom, I can definitely do Zoom. That's okay with me. I just physically can't be there on Monday.
Okay. Then that's what we'll do. We'll set a pretrial hearing for Monday. You are authorized to appear on Zoom on Monday, but on Tuesday you are ordered to appear in person.
Okay, and so this went from a readiness back to a pretrial, correct? And then Tuesday we go to trial?
Yes, so today was the readiness hearing. We're gonna set a pretrial on Monday, and on Tuesday will be trial.
Okay. Okay. And then other than that, did you have anything else for me?
Anything else you need to address today, Ms. McDonald?
No, Your Honor, I was just double checking my officers. I think we're good on availability. So
You said what now? Your offices were good on availability?
my officers, the witnesses that are going to testify.
Oh, gotcha. It was Carlsbad, I think, or something like that. Either way.
They're all listed in the report.
Gotcha.
And again, Mr. Schuster, the conditions of release in the meantime are that you make all of your court appearances, notify the court of any address changes within 24 hours, no criminal law violations, no driving without a license and insurance. I do expect you to address that Seattle Municipal Court warrant. I'm not sure if they'll be able to clear it by next week, but at the very least, there should be a docket entry indicating that you've set up a hearing to do so. And all other previously imposed conditions remain.
Are you familiar with Seattle Municipal at all, ma'am?
Yes, I am.
Because when I went to the website regarding warrants, there was a form for motions to quash warrants.
Mhm.
Do you know anything about that?
I know that some warrants can be quashed administratively and some warrants you have to show up in person.
Well,
So
just in terms of the process and how to make sure it's handled correctly. Because when I was on the site, essentially what I was getting, I just filled out the form and then submitted it, and then it sent me an email telling me that I would need to wait for contact. Does that sound correct to what you know?
At the end of the day, this hearing perfectly demonstrates why sovereign citizen defenses almost never succeed in actual courtrooms. The defendant repeatedly challenged subject matter jurisdiction, argued constitutional travel rights exempted him from driving laws, demanded an injured party, and attempted to reframe standard misdemeanor charges as some kind of illegitimate federal overreach. But the judge systematically dismantled every argument using straightforward legal reasoning grounded in municipal authority, criminal procedure, and constitutional law. What also stood out was the contrast between the court's professionalism and the defendant's constant circular arguments. The judge gave him repeated opportunities to speak, clarified procedures multiple times, arranged additional discovery access, explained trial rights carefully, and still kept the hearing moving despite endless interruptions and contradictions. Meanwhile, the prosecution's concerns about competency added an entirely new layer of tension to the case, especially after the discovery that he had an active warrant in another jurisdiction. Now the case moves toward trial, where all of these theories are going to face an even harsher reality check in front of a jury. And honestly, that trial could become even more chaotic than this hearing if these same arguments continue. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and legal deep dives. Because trust me, this saga is probably far from over.